and outline for you which are the students that we're talking about. So we're talking about students who are in foster care. These students have a current connection to the Child and Family Services Division. Many of you work directly with those kiddos. We're also talking about students who are homeless and unaccompanied from their legal guardians. So they're lacking fixed, regular, and adequate nighttime residence, and they are also not in the care of a parent or legal guardian. And then we're also talking about students who might have a stable living situation, but are also not in the care of a legal guardian. So those are our kiddos that maybe don't have that legal connection to a parent, but they are stably housed. So we're going to kind of outline all of these things in regards to these three groups of children. So just to kind of put it out there again, around being unaccompanied homeless in the McKinney-Vento Act, actually in the statute, it refers to these kids as unaccompanied youth. And I oftentimes have school districts who get confused by this. So the students who we're referencing are actually unaccompanied homeless youth. So we have to look at their living situation first to determine whether or not they're living in a fixed, adequate, or nighttime residence. And then after that, we consider whether or not they're in the physical custody of a legal guardian or a parent. So keeping in that in mind in that order is usually helpful to make that distinction. And if they are out of the physical custody, but they are in a stable living situation, they aren't qualified for McKinney-Vento services and supports, but they also are students who are going to be encompassed with some of the details that we're going to go over in this presentation. So they are students who are still in need of additional supports. So we're just going to outline real quickly what a 504 plan is. So we're talking about special education services predominantly today, but we did want to mention a 504 plan. We have a mixed group of individuals on this session. We have people who work within the schools, but we also have case managers who work with Department of Health and Human Services, Child and Family Services. And so some of us are more aware than others around some of the things that are available to students. So the Office of Public Instruction does not have jurisdiction over a 504, and we do not give advice around 504 plans, but I did want to just outline it for folks on the call so they know what we're talking about and what options are out there. So Section 504 of the Rehabilitation Act is underneath the Office of Civil Rights, and they are the ones who have authority over it. It is a civil rights legislation, not an educational legislation. So what happens is oftentimes students who qualify have some sort of substantial impairment that limits one or more major life activities. So that might be something that is temporary, like they are temporarily wheelchair bound, or it could be a longer term situation where they have a serious allergy, a seizure condition, a mental health diagnosis. That's where we see school districts developing 504 plans. So we just wanted to lay that out for folks so that you're understanding that. When we're going to jump into individualized education plans and special education services, and that is different from a 504 because there's specifically designed instruction involved for students who have some sort of identified disability. So we just wanted to lay out that difference for you before we began. All right. Annette?
Thank you, Justine. So we'll talk a little bit about this special education progression, starting with Child Find. Child Find is schools' affirmative obligation to seek out and identify children with disabilities or those suspected of disabilities that reside within the school district's boundaries. So Child Find, most people are familiar with preschool screenings. That is one small component of Child Find, but actually Child Find encompasses all the activities for locating children with disabilities in ages 3 through 21. So moving on, once we have identified that a child may have a disability, we move to the referral stage. And referral basically is beginning the process through which a school is going to be collecting information to determine whether a comprehensive educational evaluation is necessary, and if so, what evaluations are warranted. So a student should be evaluated for special education eligibility when the school has reason to suspect that a student may be a student with a disability that adversely impacts their educational performance to the degree that they need specially designed instruction. And as Justine noted, that's one of those areas where specially designed instruction is what sets IEPs apart from 504s. Um, so moving on again, evaluation plan. So this is a prior written notice form, basically, that identifies the assessment areas that the school will be looking into, and it's agreed upon by the reevaluation team. And it gives parents the opportunity to review the information, consent, or refuse the school's evaluation. Schools have 60 calendar days to complete all evaluation assessment areas from the date that they receive written permission, written consent from the parent to evaluate. So that starts the clock, the day that the school gets that evaluation plan signed and returned to them. Then we'll move into an evaluation report. This is actually an evaluation meeting that's going to be held to review the results of all the assessments and determine whether that a student qualifies for special education services. And they'll do that in a couple of different ways here. So the first would be that they meet Montana criteria for one or more of 13 disability categories. And they also demonstrate the need for specially designed instruction to benefit from their educational program. So specially designed instruction is one of those special ed terms that we'll define a little bit. It's basically adapting the content, methodology, or the delivery of instruction in order to meet the student's unique needs that result from their disability so that they can meet the educational standards of the state. Moving into an IEP, if the child is determined to be eligible for special education, then an IEP team meeting is held to develop a written plan that outlines the individualized educational program for a student with a disability. So that includes specific goals and objectives that are tailored to the student's unique needs and describes how the school will provide necessary services and supports to that student. And this is a very, very brief description of an IEP. We're going to get a little bit more detailed here next. So beginning with the IEP that's in effect when the student turns 16 or sooner if the IEP team determines that it's necessary. The IEP team will address the student's post-secondary transition needs, and that includes interests, goals, services, and supports for the student in order to obtain skills that are necessary for a successful transition to post-secondary education, vocational training, integrated employment, which includes supported employment, and also independent living when appropriate. There's also an amendment process. So prior to an annual review, so IEPs are required to be reviewed at least annually. But anytime there are changes that need to be made to an IEP before the annual review, they can do that through an amendment process. That does not always require a full IEP team meeting to do that. However, it's important to know that amendments do require parental consent in order to implement the changes to the IEP. So if the parent refuses to provide consent to the proposed changes, then the amendment cannot be implemented. So prior written notice, PWN, we lovingly refer to it, is the school's notice to the parent. So prior written notice is required whenever the school district either proposes or refuses to begin or change the identification, evaluation, or educational placement of the student, or the provision of a free, appropriate public education. The school must provide the notice in understandable language to notify and ensure parents' understanding of the proposed or refused changes. Prior written notice gives the parents a reasonable time to consider the changes, and the parent may then decide to ask questions or offer suggestions regarding the information contained in the PWN. If the parent disagrees with the school's proposal or refusal to take an action, then the prior written notice also notifies parents of the protections afforded to them in the procedural safeguards. So that includes dispute resolution procedures. Nearing the end of a student's educational progress, we'll have graduation or summary of performance. So the purpose of a high school graduation section of the IEP is to assist IEP teams in the process of determining when a school's FAPE obligation may end due to graduation, either with a regular high school diploma or when they age out of special education services when they turn 22. So IDEA requires that prior written notice be given to the parent or adult student in either of those cases. Summary of performance is also required for students with disabilities when they're graduating with a regular high school diploma or aging out of services. And this is to summarize the student's academic achievement, functional performance, and recommendations for post-secondary goals, which can be helpful for the student's transition from high school to adult life. I just want to call your attention to one of the resources that we do have on the special education family resources page, and that is a special education process flowchart. So that is a nice graphic representation of the special education process with some information about each of those steps. So we could probably move on to what is an IEP, and start here. So basically, we know that educational testing precedes development of an IEP because we need to know what the student's specific needs are, as well as are they eligible for special education services. So an IEP is a legally binding instrument that's established under the Individuals with Disabilities Education Act, and it addresses the personalized educational needs of eligible students with disabilities. The IEP serves both as a strategic framework and a legally enforceable document that outlines a student's measurable annual goals, their specialized instruction, related services, accommodations, and supplementary aids that are necessary to ensure access to the education alongside peers without disabilities and in accordance with the student's unique needs. And that last part there is a reference to the least restrictive environment consideration for students. So when developing an IEP, the team will consider the student's strengths and educational concerns, their preferences and their interests, and the results of the initial or most recent evaluation, as well as the student's academic, developmental, and functional needs. So at any stage, student participation in developing their IEP is essential. So whether that be through attending the IEP meeting or by providing input prior to the meeting. For very young students and others who are not able to provide direct input, parents are encouraged to speak on their child's behalf. However, anytime a purpose of the meeting will be to discuss post-secondary goals and services and the accommodations needed to assist student in meeting those goals, the student must be invited to that meeting. And it's important to note that IEP meeting is not a best interest determination meeting. So that would be a separate meeting. So who's considered a parent? Under the IDEA, the term parent means, and I'll read some of this to you, biological or adoptive parent of a student, including a foster parent, a guardian who's generally authorized to act as the student's parent or to make educational decisions, but not the state if the student's a ward of the state. As also a person acting in the place of a parent, such as a grandparent or step parent with whom the child lives. This could be a caretaker relative or a person individually legally responsible for the student's welfare, and a surrogate parent who's been appointed in accordance with federal and state law. So foster parents do have, under IDEA, they have full rights as a parent as long as the educational decision-making authority has been removed from the biological or adoptive parent. Uh, so that's the interesting thing there. So also surrogate parents cannot be an employee of OPI, a school district, or a public agency, or any other agency involved in the education or care of the student. And we'll talk a little bit more about surrogate parents.
So one thing I just wanted to add, if the parent is incarcerated, which would mean they are in a secure facility under the purview of the Department of Corrections, or within a county jail, or some kind of secure facility, if they have not lost their parental rights, or there is no restriction to the child, there's no restraining order put into place or anything like that, they still have a right to be part of these meetings. And it really should be advocated for that they are a part of these meetings, especially if reunification is the goal in the future. It's important for them to be part of these meetings, and they have a right to do so if they're incarcerated. One thing to know about this is that it needs to go through the caseworker or someone within the Department of Corrections or at the county level where they're incarcerated, and that they need to be present and they need to be with the incarcerated parent and facilitate on their end in the secure facility. And it really needs to they'll need to make sure, in accordance with you, that it's kept on track and that it's about the IEP or about the meeting, and that it's just safe for everyone, and that they know why they're there, what's happening, but that they are looped in if they still have parental rights and it's safe for everyone. Thank you.
I'm just going to go over a little bit too with the who some of the participants are at the IEP meeting. And again, this specifically relates to kiddos that are in foster care. And so you've seen that there's can be a variety of people that attend these meetings. And so, you know, it might be teachers, it might be the well, not might be, it will be the special education teacher, but whatever school staff are involved with them. The child protection caseworker is going to be involved in that meeting as well, or any other professionals that are working with that child that seems like it would be important to have them included in that IEP meeting. And then obviously the child's parents is important for them to be at that meeting as well. So just wanted to go through when we talk about child's parents in regard to kids who are in foster care. Typically, we always would want the biological parents to be invited to that IEP meeting, unless there are some other extenuating circumstances, like if the parents' rights have been terminated, you would not be inviting them to that IEP meeting. Sometimes there's a no contact order as well between the parent and the child. So in those situations, definitely want to talk with that caseworker because might not be appropriate for that parent to be participating in the IEP meeting as well. So if parents' rights have been terminated, then the adoptive parent would, of course, be the person that would be identified as the parent then needing to be at the IEP meeting. As you heard Annette talk about, foster parents definitely would be included in that IEP meeting if that child's not been adopted yet, and then they would be a part of that as well. And then really kind of that last piece about that legal guardianship. And so these are really those guardianships referring to through the state, through Child and Family Services. And so in those situations, guardianships mean that parents' rights have not been terminated. So if the department has finalized a guardianship through the state, then we would not have biological parents invited to that IEP meeting, as that legal guardian would be the person making those decisions educationally on behalf of that child. So in those situations, we would not be inviting biological parents, even though rights have not been terminated. So again, really encourage you to have both as child protection workers and as, you know, points of contacts or at schools, to really be having those conversations and that transparency, because communication is really important to make that determination about who is going to be important to be having at those meetings. So
I think one other thing I'd like to add about the incarcerated parent also is that it's really important to do your due diligence to find out and to make sure that the child was not the victim of that parent. You never want to traumatize the child more having the parent get on. So if they're waiting sentencing in a county jail or something like that, to really look into it and make sure that it will be beneficial for the child to have that parent at the meeting.
So just kind of similarly, we were talking about who should be at the meeting for a student who's currently in foster care. We'll just talk a little bit about who should be at the meeting in the case of an unaccompanied homeless youth. Our next slide after this is who should sign consent. So I just want to distinguish that for you. These are just people that should be present at the meeting. So obviously that parent figure, the biological or adopted or legal guardian, should be at the meeting for a student who is unaccompanied and experiencing homelessness. An individual acting in the place of a parent with whom the child lives. So that is somebody who you've probably connected with the student with that caretaker affidavit, and we'll have that later on for you as well. So that's a relative who's taking care of that kiddo, and that student lives with them. Definitely the homeless liaison as the student's advocate should be involved. The youth themselves, especially if they're old enough, and certainly if you're talking about transition plans. And then that court-appointed educational surrogate, if one is involved, and we will get kind of further into that as well. So we're going to move into really who is the consenter, who can sign to initiate that special education testing when we were talking about sort of the steps in the IEP. So in order to initiate that testing, these are the people that can sign. And also we're talking about who is the signer for if there's changes made to the IEP and you're sitting down and you're initiating the plan, or initiating changes to the plan, who can sign. So that's what we're moving into. So we'll just talk a little bit about who can sign and who cannot. So we're going to start on the left there, who can sign. So obviously we were expecting that the school is doing their very best due diligence to get in contact with that biological or adoptive parent, and that they have tried on multiple occasions to do that. Or in the case of a student who is in foster care, that foster parent is acting as the parent for the meeting. So those people must be invited, and those people can sign the IEP. So if especially in the case of an unaccompanied homeless youth, those people are not available or not in the picture, then we would talk to a legal guardian who has legal custody to make educational decisions for that child. That person can then sign the IEP. If there is not a person available in that capacity, then we are looking towards that individual who is acting in the place of a biological or adoptive parent. And this language comes from IDEA, and we have some Montana state law as well, but it includes grandparents, step parents, or other relatives with whom the child lives or an individual who is legally responsible for the child's welfare. So this is really encompassing Montana Statute 20-5-503, which talks about a caretaker who is a relative. So this is a relative caretaker, and on enrollment or when that that person has shown up to the school and says, "Hi, I'm the caretaker for this child, and I am also their relative. They live with me," then you can have them sign that caretaker affidavit. And that is all discussed in this Montana 20-5-503. And if you don't currently use a caretaker affidavit, if you just put into Google any of our AA schools, most of them are available online, so you can see what it looks like. And then you can work on developing your own for your school district. So then we also sometimes have students who don't fit any of those. We don't have any of those adults in their life. Maybe they're living with a friend of a friend, or they're living with a friend's family. That's not a relative caretaker. And so once that happens, the school needs to initiate with youth court to get a surrogate parent appointed. And that is stipulated in the following, that IDEA code, and we're going to talk more about that. So if any of these people are not available, then the school district needs to initiate that court-appointed educational surrogate. So, additional clarification: who is not able to sign the IEP? The Child and Family Services Division caseworker may not sign the IEP. That is not per IDEA, so that is not aligned with the law. School district's homeless liaison or other school district employee may not sign the IEP. There is a little star here because the McKinney-Vento Act and IDEA say that there can be a temporary educational surrogate appointed, in which case that homeless liaison may sign the IEP, but our advice to you is to find a different individual who is not associated with the school, so that you can have that long-term surrogate parent appointed by the court, and you don't have to continually go back to court to make those changes. But that is why that little asterisk is there. And any parent who lacks the educational rights are also not able to sign. And so we have a little list here as well. These are all of the statutory references for you if you want to look at the law and where this information comes from for your reference. But those are who can and cannot sign for the IEP.
So jumping back to the educational surrogate parents, school districts will assign an individual to act as a surrogate parent for a child with a disability whenever the parent or guardian cannot be identified, if after reasonable efforts the location of the parent cannot be discovered, or if the child is a ward of the state and the foster parent is unable or unwilling to act in the place of a parent. This decision needs to be enacted by the school district as far as taking the documentation necessary to youth court and making a suggestion for an individual to act as a surrogate within 10 days of determining that the child needs to have a surrogate parent designated. There is the state code that's related to this, and then the person nominated as a surrogate parent must be an adult who's not an employee of the state or the school district that's providing educational services to the child. And the school district will reimburse surrogate parents for all reasonable and necessary expenses that they incur by acting in this capacity. There is in our references or resource page, there is a brochure that is for educational surrogate parents attached there. So I would encourage you to review that information for any clarification.
Okay, so we're moving on a little bit to talk about some transitional services. So, what does it look like, when kids are transitioning out of special education, to that post-secondary life? And Annette briefly alluded to that earlier in the slides. So for students that have disabilities that are kind of getting to that end of their public school education, transition services help prepare them for that life after high school. So that might include things like that vocational training, job placement assistance, independent living skills, trainings, and things like that. Anything that's identified really by that IEP team. So the Individuals with Disabilities Education Act then requires that there has to be a transition plan that's included in that IEP, and that that has to be in effect when that child turns 16 years old. So as part of that, that transition plan outlines those services that have to be provided to help that student with disabilities successfully transition from high school to that post-secondary life. So in Montana, then, we have what's called the Montana Transition Framework. And so that is the program that really is designed to help with these transition services. And so as part of that program, the students' high school courses are reviewed to see what that progress has looked like for them and what those graduation requirements are. Help with developing that customized plan for the student's future. Really is looking at exploring those careers. So is it job shadowing? Is it internships that can be provided and link them to those? Also taking a look at that information, about what educational options are really available for them. So is it college? Is it vocational training? What is going to be best for that student? And then again, helping connect them with those community resources. So might be job placement services, rehab services, things like that. So, Annette, did you have anything you wanted to add about information for this?
No, I think that you did a fantastic job. You got it all.
All right, perfect.
All right. So moving along to graduation and free appropriate public education. Most of you are aware now that the law in Montana recently changed to align with IDEA standards or requirements. So now in Montana, schools have to make special education and related services available to students with disabilities through your 21st birthday, through 21 years old. So that is up until their 22nd birthday. I'm going to get that right. At age 18, educational rights accorded to parents under IDEA are transferred to adult students unless other legal arrangements have been made. And previously, it used to be students were directed or parents were directed to obtain guardianship, legal guardianship over their student prior to the 18th birthday if they were not able to make educational decisions for themselves due to the nature of their disability. So at least 1 year prior to student's 18th birthday, schools have to inform parents and the student that's about to be an adult that this transfer of rights will occur. And that gives the school and the parent, actually the parent, time to start working on any different legal arrangements that need to be made if the child will not be able to advocate for themselves. So just something to think about, and that is jumping back to why at age 16 we start transition planning, because some of these kinds of educational legal requirements take a little bit more time, and so we need to start planning ahead for that. But there are alternatives to guardianship that are available, and one of the resources that we've linked on the resource page also is Rural Institute's Alternatives to Guardianship. So read through that information if you have questions for what alternatives there are available. So graduation with a regular high school diploma that meets or exceeds the Board of Public Education's graduation requirements will end the district's obligation to provide special ed and related services to individuals, as well as when they age out of services, so when they turn 22. But only graduation with high school, regular high school diploma will end that. It constitutes what we call a change in placement. and ends the district's obligation to make FAPE available. So if the student received a credential that is not a regular high school diploma, that doesn't meet or exceed the Board of Public Education's requirements, then the district is still obligated to make FAPE available to the student until they either meet the requirements for that regular high school diploma or age out of services at 22 years old. So it does any kind of a diploma that's based upon like IEP goal completion is not considered to be a regular high school diploma and does not limit the district's obligation to provide FAPE. So only a school board's district's board of trustees are able to waive specific course requirements based on individual students' needs and performance levels. So it is incumbent upon the IEP team to follow local district policy when considering graduation waivers for students with disabilities.
All right. So taking a look at just, what is your role depending upon um, what that entity looks like for you. And so if you're in the role as a child protection worker and or that foster child's caseworker, there are a variety of things that really need to be doing in order to be part of that educational well-being for kids. And so one of the biggest things that we do here is that schools don't often know when kids are in foster care and come into schools. And so one of the most critical things you can do as a caseworker is really to have that contact with the point of contact at each school. And again, if you need that list of point of contacts, please feel free to reach out to one of us. It's on the OPI website as well, but definitely want to get you connected to the right person. But really is critical to let that school know when kids are entering foster care, as well as if they're changing placements. So or if reunification has happened. And so needing to let that school know. So if parents are not supposed to be there, is it okay that they are and they're making the decisions for kids? So really important to have that communication as the caseworker, with your local schools that your kids are placed in. So again, that kind of piggybacks off of, being that liaison between the family and the school and making sure you can help coordinate, should that biological parent be involved? Are their rights terminated and what's that look like? And so really having those conversations with, between those two to make sure that we are getting the right people at the right meetings and being involved in that. So a lot of times caseworkers are going to have that special knowledge about kids for the IEP team. So very important for them to be in those meetings. Because they do know more about that history of kids and being able to answer questions potentially as well. So really can bring that role to the table as well.
And from the schools side of things, we need to make sure and hold timely meetings. Sometimes we have foster students that are temporarily placed with a family and then placed with another family soon after. In a more permanent situation, or again, could be temporary, but we don't always know when students are going to be moved. And so for schools, we really need to be mindful of the fact that when a student is in foster care, they may be moved around or relocated. And we need to be sure and hold timely meetings. So, one of the other things that we can do to really help support the students' continuity in their educational programming is to ensure that timely record transfer occurs. So we'll facilitate sharing assessments, particularly if we're in the middle of assessing a student that is a foster child and they are relocated. We know that the 60-day timeline doesn't apply in those situations, and if the parent and the school district agree, but we need to make sure that we're sharing assessments information as quickly as possible to the receiving school and making sure that they have all the information that they need to in order to quickly implement the student's educational programming if they're on an IEP. And under OSERS has, the Office for Special Ed and Rehabilitative Services has a letter on highly mobile children. It's guidance. It's informal guidance, so it's not binding, but best practice is that foster children are considered highly mobile students, and we want to expedite any of their evaluation or IEP processes possible. So, okay.
So we've collected a lot of really great resources for you to do, and their documentation of sort of the key points of our presentation. So we really would you to take a look at these things a little bit as you have questions that come up and that are applicable to your situation. We're also available to you anytime, so please feel free to reach out and we can help guide you in the right direction as well. And now we will open it up for some question and answer. So I saw Lisa has a question in the chat. The legal guardian, could the legal guardian be a CASA? Natalie?
Typically, no, I wouldn't think that the CASA would be a legal guardian. That's going to be speaking mostly to the those guardianship orders that come from the court when we have finalized a guardianship. So it's sometimes really confusing between foster care kids and like regular guardians, but typically the CASA would not be considered a guardian.
All right, we have another question in the chat. What is the appropriate process for a school district to receive official notification when a child has been returned to their parents' custody, particularly in situations where the district's most recent information indicates that children was placed in foster care and that the parents were not permitted to pick up the child? In other words, what documentation or communication should the district expect before releasing the child to parents? Awesome question.
Okay. So asking about what documentation should the district expect before releasing the child to the parents. So again, that comes back to that communication with the worker. I think that the district, if they are aware of who that worker is, definitely be reaching out to them to find out, what that's going to look like. If reunification has occurred, if the case has been closed. Again, that point of contact, we have that memorandum of understanding. So caseworkers can, provide that information to that point of contact. And typically, the child welfare worker would be, having that information to provide for them. So I would definitely encourage you to reach out to that worker and find out, where that's at in that process. Again, from the other standpoint too, of making sure that if you don't know who that worker is, please feel free. You can certainly contact me. I'd be happy to point you in the direction of who the worker is. Their supervisor or regional administrators are also, willing to help out with that as well. So I'm not sure if that answers the question or not, but.
Feel free to come off mute and ask your question, or you can put it in the chat.
If there is a no contact order, just to kind of follow up on that, then again, having that documentation from the worker. And again, that's why really just trying to have contact with that worker to find out, they can provide you with that documentation to further clarify, what those rights are and where that's at in that case.
I'd like to just add one thing before we go today. Also, with the best interest determination meetings and the IEPs, they are two separate meetings, and you'll need to have both of them. The IEP meeting can drive the best interest determination meeting, and be a crucial part of it to make the best interest determination, but they are two very separate meetings, just to keep that in mind.
If you think of
Marissa?
questions too, oh, sorry. Go ahead.
No, you're just fine. I was just going to ask if we could talk a little bit more about what that best interest determination meeting is for our school folks, because they may not be as familiar with that. Thank you.
So thank you, Annette. I love talking about this stuff, so I'm glad you said something. I think the best interest determination meeting, I'm probably preaching to the choir here, but it's so important to know that a best interest determination meeting needs to be held if there's a change in placement or there's a new placement, and it needs to be held within 3 school days. So as soon as you find out, that time starts ticking, and it needs to have the administrator, the parent, school counselor if possible, the caseworker is crucial. And we are always happy to help facilitate those or to help you get started. And on our website, there is a best interest determination fact sheet. But it's really important to sit down as soon as that placement is changed or there's a new placement to make sure that all the transportation is in place, that they're definitely getting all the services that they are entitled to as a student in foster care or a homeless student. But I think it's also really important we hear things like they're not getting their free lunches and things like that, and to make sure that that's happening, and that you have all their records and things like that. So it's just a really good place to start, and also to make sure that the best interests of the student are in place.
Just a real quick caveat. So the best interest determination for students experiencing homelessness is a little slightly different. We have some guidance from the Department of Ed that really indicates that the school of origin is usually the best placement for a child just for educational continuity. And the school district should really look to the parents or the unaccompanied youth to make that decision around placement, so most of the time a child experiencing homelessness is going to stay at that school of origin unless there's some extenuating circumstance where it is not in the best interest of that child. So, and if you ever get in that position where you think maybe it's not in the best interest, please just reach out to me and I can help guide you through the process.
And if you have questions beyond today, we've had great audiences with reaching out to us after the training too as well. And I think Justine maybe could put our email addresses up there too, or with our phone numbers, and she'll send out the PowerPoint as well. But if you think of things after this or feel like your question wasn't clarified enough, please feel free to reach out to us, and we're happy to either answer your question or definitely can get you to the right person to get that question answered. So just want to make sure that everybody is kind of aware how to get a hold of us, and we're happy to try to help you however we can.
We are looking forward to April. I can't believe I'm saying that, but our next Lunch and Learn will be April 2nd from 12 to 1, and we will be discussing data, collaboration meetings, GEMS data, what that looks like, how it drives funding, how it helps programs. And Natalie will be discussing post-permanency support. So it's going to be another great one. We will be sending out more information soon, but I just want all of you to know we appreciate all of your work so much. It does not go unnoticed, and you all are making a difference. And it's sometimes a really hard line of work, but we can't thank you enough. And we also want to thank Annette for being here today. I learned so much. You are an expert in the field, and we're so lucky to have you today. So we will see all of you in April. And if you have any questions, don't hesitate to reach out to any of us. We're happy to help in any way we can. So have a great day, everyone. Thank you.
Thank you.